Thank you very much. Thank you for the invitation to our host. I have the not so pleasant task to speak you before dinner, but before lunch, sorry. I hope it will not take until dinner. This is the idea. The idea of this presentation was given, unfortunately, by the so many changes that we experienced in Romania as regarding regulating sexual offenses into our criminal code. I think that sexual offenses did rise up to the point that they are, let's say, an constant electoral debate among the politicians in Romania, unfortunately. So we will have a few remarks about the legal provision, the history of the legal provision, a few remarks about the changes, a few remarks about the actual continuous reform that are populating, let's say, our juridical life. Let me bring you something from the past. We had a criminal code from 1968 that was repealed only in 2014. And within that code, we had a regulation criminalizing seduction, where the passive subject was a female person, a girl, under the age of 18, in the context that her consent to sexual intercourse was obtained through the promising of a marriage. That was one of the very interesting texts that we had in the previous regulation. Now there is not such a regulation, such a criminalization anymore. We had a constant reform, as I said, and this is still is one of the, let's say, victims of this reform, if you consider that no female person or male person should be protected like this. It's very hard to, let's say, to imagine in the present days such a text criminalizing an offense. But on the other hand, maybe we can talk about other form of protections in this regard. Also, from 2000, the year of 2000, by Law 197, actually that was the moment when we addressed the problem of protecting family members expressly, in the sense that in regard of sexual offenses, and not only sexual offenses, we introduced first a security measure, prohibition to return to the family home for a certain period, because a lot of domestic violence did occur in which the police did not have any instrument, the police, the prosecutors, and the court did not have any instrument to put aside or away the aggressor. I will pass through some slides in the sense that I will underline only what I think it's the most important aspect to be underlined. I understood that also this presentation will be published. As you can see in the letter B, we have criminalized expressly, consecutively after the law from 2000, the rape against a family member. Because previously, this offense, criminal offense, was actually, let's say, non-academic term, was divided between two other offenses. One was rape and the other was incest. So there was a balance when we should enforce one or we should enforce other text. If we are moving further, as I said, we have the new criminal code, not so new now, in 2014, but the definition of the rape is rather curious in the sense that we have paragraph 1 defining the criminal offense, but we still have paragraph 2 saying with the same punishment shall be sanctioned any other acts of vaginal or anal penetration committed under the condition of paragraph 1. I cannot understand why also these circumstances were not introduced into the first paragraph, and to have only one, let's say, precise or more concise regulation. Also, the good thing, on the other hand, is that through this law, we now have express criminalization when the victim is in the care, protection, education, guarding, treatment of the perpetrator, and we have reinforced the provision to criminalize in an aggravated form when the deed was committed by a family member or a person living with the victim, which was or is not formally a family member. If we are moving further to this, let's say, history, now the game begins in the sense that from 2021, we have 4 laws changing the framework, at least 4. In the sense that from 2021, an idea of reforming these sexual offenses was introduced. First of all, the legislator introduced the rule of non-statutory limitation in the case of sexual crime perpetrated against underage persons. That was one of the consequences, I'm saying, of this report, in the sense that this report, drafted by the Service of Inspection under the Superior Council of Magistracy, sorry, I have to close. Some colleague is calling me now. This report was drafted when the judiciary body first and then the prosecutor body saw that there are different, very different approaches as regarding sexual offenses in Romania. What I'm talking about, as you can see on the slide, the idea is that we had rather a confusing regulation. Up to the age of 15, at that moment, there were 2 criminal offenses. One was rape and one was sexual act with a minor. The difference between them was the lack of, let's say, the lack of consent. But may I ask you, if the passive subject is a 7-year child or 10-year child, and he or she expresses consent to that sexual intercourse, then this consent is valid? So we can take it into consideration and enforce the provision from sexual act with a minor? I think not. But some courts decided that is okay at 10, 11, 12 to give a valid consent for sexual intercourse, and consequently they activated for that deed, the provision from the sexual act with the minor. Of course, that provision is more favorable to the active subject. It's not rape, it's a sexual act, consented sexual act with a minor. And that was the very central and the initial problem of, can I say, duplicity attitude of the judiciary system against minors. Whenever you found this possibility that, oh, he or she gave the consent, so it's not rape, and not taking into consideration all the factors, as mentioned before, the factors that can construct a consent in case of a child, then I think it's wrong. It's wrong, and we should have done more about it before. The other ideas that are inserted in this report are ideas relating to procedural rules. How the procedural rules were enforced when examining an underage person that was passive subject to such sexual crimes. Because the attitude of the interrogators, the police, the prosecutors, also the judges, was not always a friendly one, on one hand. On the other hand, when such crimes were perpetrated, you can imagine in one case the motivation of the court not to arrest the defendant was that there were no public riots. There were no public opinions as such expressed, and since there was no public echo of the deed, it's not important to put away for as a temporary measure, a preventive measure, that defendant. In the end, we had to take into consideration and let's say, to put for the future in front of us this recommendation of the report. 1, 2, 3 of them were also integrated into the criminal code, especially criminal procedure code, For example, the one with the green. Now the hearings, the examination of underage victims are only carried out in the presence of a psychologist. Before it was not the case. And now we are starting to build and to construct, to set up rooms especially designed for child witnesses, child victims, child offenders examination, which is very good, because those rooms are with special glass, with all the features that you need to obtain real information, not influenced information or other information that are coming from another reality. When drafting my paper and my chapter into the book that I've prepared for CAA, the law 217 from 2023 was in force. Yes, this is the conclusion. And from the moment that I delivered the chapter, our legislator thought that in the last working day of the year, 2023, we should do something. We did not have anything on the agenda. And they found out that some provisions from this law are not okay, are not effective. They are, head to head. I cannot detail because of the time, but they thought that they have to change it. And in the last working day of the 2023, a new law was issued, changing at least 1/3 of the previous modifications, which were issued in July. I'm telling you this to understand the chaos that is arising from this situation. Not only that they are sensible things, but to change it so often, it's I don't know, like you are working against the victims. I don't know how should I. I presented the new modification, but the main idea is that we have now a special statutory rape, in the sense that under the Article 218 Index 1, if the act was committed against a person who is up to 14 years old, then it's rape, irrespective that did not express the consent, and so on. So we have, let's say, now I'm thinking to say that we have a starting point, not only now, because previously there was this debate that affected the practice. Let me pass to the conclusions. Only one thing, that recently, after the last working day law, they modified again, and from 1 to 5 years in case of child pornography, they raised the penalty from 3 to 10 years, without any, let's say, reason. So, the idea to tighten the penalties, the sanction, the punishment, does not work always. The idea to make it without any limitation of prosecuting and trialing proves, I think, more or less the inefficiency of the judiciary and the prosecutors. And the idea of tooth for a tooth is not always working so good. All of these three ideas are proven by, let's say, the big number of the statistics as regarding this kind of offenses. Thank you very much for your patience, and